You can't be perfectly invisible because once someone's in court, myself, if I represent a tenant, or it doesn't have to be a tenant, someone ends up suing you. It could be a credit card company. It could be a mortgage company. It could be a second lien saying you're in default. Now we're going after you. Where's your property? You may be protected and hidden for a while, but most types of lenders and creditors will do searches across the country. But if you've kept yourself, so it makes it more difficult. That much I know. And to get into, there's offshore trusts you can get into. I mean, some real technical items out there to do just that. But no, once you're there, what the IRS has done recently is the IRS says, okay, you want to go offshore? That's fine. But guess what? If you miss your filings with us, because you have to file with the IRS, now your penalties are like 10 grand, 15 grand if you miss it. And they don't waive it on those like with your 1040s and personal returns where you can get things waived. They don't waive it on that. And they're not good at it, but they're good at taking your money out of your bank account. So just know that in terms is a very good point. And real quick, a few items that the savvy real estate entrepreneur should know dealing with the operating agreement. You want to make sure you have financing information in your operating agreement, especially if you have partners. We have a group that we're looking to work with, and they have, right now they have 4 partners. And the question is, what happens if the operating agreement is silent to profits and everything else, or if you don't have an operating agreement? Then, Michigan law does have laws in place for you. I'm not here to say you have to have an operating agreement. You should, because it's an important document to have in your arsenal to help protect you and illustrate, if you have multiple partners, as to how the splits are going to be. If you put all the work in, if Terry has multiple partners and you put all the work in, and you're going to get 80% of the sweat equity, but it's not indicated in there, now what happens? We're trying to stay out of court. When we're in court, I'm going to make it sound real nice that you weren't the one putting all the work in, because I'm going to do the things I have to do for my client, and it may not look good on you. So what are you more apt to do? You might settle. At that point, you probably pay an attorney, and now you're really upset. You're not having fun that day. So this is about getting the emotional part out of it. That's what some of these hopefully small trinkets of information are. In addition, one of the things that I wanted to mention real briefly that the IRS is starting to do with the influx of everyone, not everyone, but a lot of individuals trying to just get into the market of what many of you do, is to to call it a dealer status where if that's the case, you now may lose additional tax benefits. From capital gains to 1031 exchanges, and I don't want to get into. I think there was a CPA that probably spoke here, may have spoke briefly on that. I don't want to get into the technical part, but just know that there's items out there if you are doing multiple. And when I say multiple, I mean if you're flipping homes every 2 weeks in multiple homes, you may want to look at and have your CPA accountant and or attorney look at whether or not you potentially could become call under dealer status, because you might lose some of your tax advantages. So it's just be cognizant about it. Most of the presentation isn't based on that, but I thought it was important for what we in turn were going over. And of course, anytime you're dealing with the IRS, you want to document, and it's based on your intent a lot of times. So the only way to get that is from documentation. The 5 main estate planning documents that everybody, now we're at the main event. The 5 most critical documents that every estate plan should have, and by the way, most planners, and I've studied under some pretty good planners, have 4. I'll get to what the 5th most critical document is here in a little bit. Everyone's heard of a will. Please tell me you heard of a will. How many of you have had the pleasure of going through probate court? I don't mean just driving there. Has it been a pleasure to go to the probate court? For some of us who may not have been, and sometimes the unfortunate part, because you have a loved one passed away, presumably, but why you don't want to be there. And a will is a guaranteed ticket to probate court. So how many of you want your guaranteed ticket? Then if all you have is your will, and usually the wills were done, here's why they were done back, or why the big push was for wills. Because what happens when someone dies? They go to the attorney. There's a reading of the will. Supposedly, there's really no technical requirement for a reading. It's good for the movies and books. And maybe I should start doing more readings and charge all family members. No, I'm kidding. But the will aspect allowed the attorneys to start charging. Because now what they do, they created an annuity for themselves. It's like having a own built-in tenant coming forward when someone dies going, great, I get to take the family, because the family, mom, dad left a house, because everyone, usually, house usually paid off. That's how a lot of us grew up. A little bit of money in bank accounts, or a lot of money under a bed if you were one of my grandparents, or stuck in shelves somewhere. You had to find it. Hopefully you didn't sell it before someone else got to it. And the attorney took their share. 5, 10, 15 grand, 15%, 10%, 5%. And the family at that point just kind of said, well, just the cost of doing business, right? That was the impetus for why wills were pushed and not trusts. Trusts have been around for some 30 years. They come from British law and things like that. But that's one of the reasons why you don't want a will. I'm going to talk about it. A will is actually a safety net, and it's part of the estate planning package that every attorney that draws one up for you. Because if you go forward with a trust and you bypass probate and you have your medical powers, but then say you buy another piece of property, and now you're building that property, and you didn't go see Joe to transfer your property into the trust. Now what happens? Well, the will is a pour-over will, so the will, here's where probate court does work. You go into probate court, you say, here's the will, it pours over into Terry's trust. I don't want to pick on Terry, but he's in the front, so we can. I know, but he's further away. Into Fox's trust, too. You now get to pour that over into your trust. That's the one aspect that the probate court does handle. They handle titling a property. They usually do it pretty well, but if you have other assets that are in there, guess what you have to do? You have to notice everybody. So on your point of trying to be invisible, guess what? Everybody needs to get a notice. And when someone gets a notice, Uncle so-and-so passed away, wow, I wonder what happened to that other property. Wonder when that property went into a trust? No, that property was mine. Don't let them get to that point. That's why we in turn have, and I'm going to talk in a couple minutes here about one of the main reasons why an estate fails is because of lack of funding. You'd be surprised. I see, and there's a lot of good estate planning attorneys. I'm not going to deny that, but they don't take the time to transfer your property into a trust. For the savvy real estate entrepreneurs who you know your ins and outs of your business and what you're doing, but if you don't take the time, if you have multiple LLCs, to transfer them into your trust, then guess what? You just created a one-way ticket to probate court for your family. And for the attorney, please leave my card there so when they call, I'm more than happy to work. I love working. I may not charge 22%, but no, I'm kidding. But I don't mind doing the work for it, but really, there's on small estates, $200,000, it's not uncommon for attorneys, probate fees, court costs to add up minimum $10,000, $15,000. And that's easy. That can be done in a matter of months. And you're going, what just happened? Don't do that. What does the trust do? Here's what the trust does. Here's what you need to know about a trust. The trust has 4 parts. You have a grantor, it's usually you transferring property. It has res, Latin for property. It has a beneficiary, usually kids, loved ones, whoever else. Don't put mistresses, put them on your insurance. No, I'm kidding. The trustees and beneficiaries. So the trustee's there to act on behalf of the beneficiaries. The property is there into your trust. If we had one of the water funnels, if this is the trust, all the property has to go in here, because if the property's out here, guess what? The attorney gets to take the money. Think of it that way. They're going to get their money somehow. Not just the attorneys, but the courts. The courts love to take your money. It's $150 just to get into the court. Unless you're indigent, you can file an affidavit. And then there's $20 every time you want to file something. Every time you want to go see the very nice people at the clerk's office, you pay them to see them. And those have actually gone up in the last 5 years, the number of filings for estates. If you don't have a documentation of the transfer, and it's a transfer of LLC, if you have a C corp, correct. The simple answer is yes. Yeah, the transfer document is not like, nothing gets recorded like what you would think of with quitclaim deeds. And I'll talk about that in a second. You're right. Quick and simple is you should have your transfer, unfortunately it's called transfer of LLC interest.